Hello, everybody. Hello, welcome. Good to see you. Hello. Good evening. Trying to get my situation sorted here. Hello. Hopefully, everyone is having a good Tuesday. So, welcome in. Hello. Good to see you. Welcome. Hello. Yes, happy to be here. Absolutely. I do need to check my ring though tonight. I'm wearing just started. I'm wearing my onyx, but I'm wondering if it's if it's reflecting the ring light too much, everyone. Do you think that this is too reflective? Is that going to be a distraction, do you think? I'm wondering. Hello. Yes, welcome. Yeah, I'm wondering. So I'm curious. I have two rings here. I have this onyx tonight, but no, it's fine. Okay, well, here's option 2, everyone. So while we're getting the notices out, so here's option 2. Here is another one. This is another favorite ring of mine. It's okay, the ring's okay. How about this one? What do we think? Is this one okay, or is the onyx better? Hello. Welcome, everybody. Good to see you. Yeah, slightly distracting. Yes, that's what I thought too. This is one of my favorite rings as well. Option 2. Okay, the second one's better. Second one's distracting. Oh no. Either way, this one. Okay, love the second one. All right. Well, let's go back. Let's just double check. Good evening, everyone. I'm giving everyone a chance to come in, so I'm having to decide these difficult choices. All right, here's option number 1 again. And then we had, okay, number 2. Okay, second one matches your nails. I thought so too. I thought it did too. Okay, take a poll. The second one. Okay, number 1. All right. Yeah, it's a hard choice. I'm noticing that the ring light is really reflecting off of my onyx tonight. So number 2, number 1. Oh my gosh. So this is just a lovely artistic piece here. It's not a particular stone. It's a sketching in here that's been outlined. So number 2. All right. Well, let's go with number 2 for now. But we might do the onyx tomorrow. I mean, that was kind of my thought also. So I just said I would, chime in and see what everyone was feeling tonight. So, okay, I usually like to wear the onyx one when I wear my black shirt, and this one has more green in it, and so I usually wear it with my green cuffs. So I just wasn't sure tonight, so I'm glad I asked. So, well, welcome in, everybody. That's enough of that distraction. Welcome in. Happy Tuesday, everyone. Happy Tuesday. Good to see you all. I'm glad you could join me. So everybody, I was able to print out the transcripts. Oh my goodness. So, I have been going through what's been going on in the trial over the last few days, of course. And I've been doing my best to kind of mash together all of the reporting from the people in the room. And it has been a little bit frustrating for me, honestly, and I think for everyone, because we're not in the room. We don't know exactly what everybody is saying. So I have been a little bit frustrated, especially, we were talking about those objections last night, and I just wasn't able to get a full view of how the objections were handled because there was reporting in lots of different places. So now that we have the transcripts, I am so very, very excited. Now, the caveat that I will say, and I am planning to read through the transcripts, is that they come out the day after the court session. So we'll be a day behind. But for me, I'm willing to be a day behind for the accuracy that we're going to get from having the transcripts. So I'm very excited about that. Yes. Oh, thank you so much. Thank you. So I think we get a lot of reporting on what's happened during the day. And of course, if anything spectacular happens, I will make a post about it. But I think I would like to go forward using the transcripts to kind of go through and explain what's happened because we have a much more accurate picture then. We don't have to rely on the people hurrying and scribbling things down when they're in the courtroom. So that'll kind of be my thing that I'm going to be trying to work through for this next couple of days. We'll see how it goes. So with that, I have yesterday's transcripts then to go through. And I think these are super helpful because we have the Sandoval hearing holding, and we were not able to actually see exactly what the court had held. So this will be great. We can go through his entire holding on that. And then we also have the full maybe a post. Yes. Well, we'll see. Let me run it by you. We'll have the full oral arguments from both defense and from the state. Now, the great thing, love the nails. Oh, thank you so much. The wonderful thing about these transcripts is that every single page at the top, and I want to show you this, so I will probably show just a picture up here and then I'll read through the transcripts down here. But on the top of every single page, it says what it is. So it says that it's a jury trial and then the preliminary, so this is the Sandoval ruling. And when we get to the top, when we get to Mr. Blanche or when we get to the state, it says exactly what it is. So yeah, Cozy, I know, because I was thinking, all right, let's get the sticky notes ready. But every single page is labeled, so every single one of them. And I'll make sure to have this in the frame as well as the page number here. Let me make sure the page number is in as well, so people can follow along at home if they're interested. So if anyone is hopping on and they're saying, well, we're not really sure what it is, then exactly what it is at the top, and then the page number is here. So Blanche is one of your favorite Golden Girls. Mine too. I love them all. What am I saying? So it's very helpful, and they have split this up into just a couple of different parts. We had the Sandoval ruling, we had the ruling on the Access Hollywood tape, we had the court's opening statements to the jury. We also had the court's instruction to the jury. So each one of those, and they're all labeled on each piece here. So it should be very easy to kind of follow along and see exactly what's going on. So page number's not in frame. Okay, so you'll have to let me know. I'm using a couple of screens, everyone, when I do my lives. And so the actual camera is set on a different screen. So if it does get out of frame, please tell me. I'm happy to kind of move things around because the screen's sizes are a little bit different. So where can we get the transcripts? So all you need to do is just go in and put in New York criminal trial transcripts, and based off of that, it's going to pull up and I'm not sure exactly which will be the first, but you're going to be finding the press release by the New York courts, and the New York State courts then has a link directly to where you can find it. So that's the best way to do it. And again, depending on where you're at in the country, you'll have something a little bit different that'll pop up, one or two. So it's really, the key is the phrases that you're using, the keywords that you're using. So I think, okay, Cat Juice, yay, you're here. We can start, woohoo. So I think that's going to be very helpful for everyone. Again, I think this is so great that they're allowing the public to have access to these. Again, we can, as attorneys, we can earn even, the public can go in and look for these transcripts, but they are very expensive and they can be hard to find too. So this is really an amazing gift, basically, amazing process that the New York courts are doing for us here. So very thankful for that. And happy to be able to kind of jump in and get started on this. So we've got quite a bit. We do have both opening statements I do want to get through. I will probably stop at the point where we end before we start getting into Mr. Pecker's testimony, because I would like to do Mr. Pecker's testimony in its entirety tomorrow is what my plan is for that. Thank you, Shannon. Thank you very much. Yes, why are they expensive? Right, they're expensive because the court reporters that put them together have to and do charge, and it is appropriate for them to charge a certain amount for them, and they're very expensive. It's a very difficult job to do, and it's a very difficult process. So they're expensive based off of everybody in the state. So all of our court reporters are charging the same thing, and they certainly aren't going on giant yacht cruises like Mr. Thomas. But, oops, sorry, that one got away from me. But, that's just part of the process to go through and to use all the equipment and all of those things in order to get them copied. So it is very expensive. All right, so here we go. Let's go ahead and jump in. Now, after each section, I will kind of pause and do a Q&A after that. For all of my moderators, yes, so Michelle, what I do plan to do then is to kind of do a recap of what has happened during the day. But, if there's nothing that's been too exciting that's been going on, I won't spend a lot of time, only because I don't have the accurate information. Before I was kind of piecing things together, and that's helpful, but to actually have the true accurate information, I think is really good. So, all right, everyone. So, and again, moderators, just do whatever it is that you need to do. I appreciate you all and trust you all with whatever it is you need to do. So let's go ahead and get started, everyone. Yeah, so let me grab my pen here. All right, let's get started. We've got the people of the state of New York here versus Donald J. Trump, the defendant, falsifying business records, first degree. Now, I do only have half of these in the frame because the rest is a picture. On the bigger screens, if you're watching this on a bigger screen, you'll see the full transcript. So here we go. Have you had your tea? Yes, I have 2 cups of tea ready for me. So, oh my gosh. Oh, and I've got to figure out voices too. No, just kidding. Of course I've got voices figured out. Okay, here's the court. Now, the court is in pink. The state is in blue. The defense is in orange. And so those are the primary colors that will be used throughout this. Oh, thank you so much. Oh, I appreciate that. So these are the colors I'll be using. So in case you're wondering who's talking, I will be following along here, but the color is really what's going to tell you the difference between who's speaking at the time. So here we go. Let's get started. So here's the court. Good morning. The people of the state of New York, indictment 71543 of 2023. Appearances, please, starting with the people. For the people, ADA Joshua Steinglass, Matthew Colangelo, Susan Haffinger, Christopher Conroy, Becky Mangold, and Catherine Ellis. Good morning, everybody. Good morning. Good morning, Your Honor. Todd Blanche. I am joined this morning by President Trump and the rest of the team. Emil Bove, Susan Nachellas, and Gedalia Stern. Good morning. Good morning. Good morning, Mr. Trump. So we have a couple of housekeeping matters to take care of before we get started. People, how long do you expect your opening statement to be? Your Honor, about 40 minutes. Okay, Mr. Blanche, about 25. Okay, that's fair, because unfortunately we are going to have to break a little bit earlier today, or a lot earlier than I had anticipated. We are informed this morning by juror number such and such, which I will not be giving that information out. Oops, I had thought that I had crossed all of those out, but there we go. Who is an alternate number 6. You may recall that she had a toothache last week. She was able to make an emergency appointment today at 3 o'clock, perhaps because of the holiday. I don't know why that appointment was moved up to 1:20. So I told her that we can break at 12:30, and I think that's just something we have to do to make sure we don't lose an alternate. Can I just ask you a quick question, Judge? Would it be okay for logistical and bathroom purposes if after the opening we take a short break to get our witnesses upstairs and to go to the bathroom? Sure, of course. The other issue is we received a call on Friday from a juror who was a juror number such and such, and I did not speak with the juror, but my understanding is that the juror was concerned about the media attention and wasn't 100% sure if they wanted to be here. The juror is here today. I think we should speak with the juror. I see we have a courtroom full of people. Right, everyone. Now, I will say here we do have this discussion that went on with the juror. I am not going to read through that. You can pull that if you're interested in that. They did ask the juror how they were feeling because of the media attention. So next, the court says, thank you. You can go back to the jury room. And then we will move on to the next page. I am, again, just kind of skipping through here. You'll have to forgive me about that. So, here we go, 422. Oops, we're missing 423. Well, we'll just skip forward then. Here we go. And thank you. You're welcome. That's fine. Anybody wish to be heard on that? We have no objection. Counsel? Nothing new, Your Honor. So again, they're all agreeing to allow the juror to make their own decision in this particular situation. So there we go. Thank you. There was also an issue regarding an Access Hollywood tape last week and to what extent the people would be permitted to elicit information about it. I promised I would go back and review the transcript. I did. I don't really see the confusion. The issue of the people introducing a transcript was never raised or not raised, or what was raised was that the people would be permitted to go into what was discussed in the Access Hollywood tape and that the tape would not be played. If the people were to request and seek to introduce a transcript, I would hear argument of both sides as a matter of evidence, not as a matter of this is the Access Hollywood tape and therefore some special rule applies. This judge cracks me up. At this point, I don't see any reason why a transcript which accurately summarizes what was said in the tape should not be admitted into evidence. Thank you. I will hear you on that. Your Honor, we obviously objected for the reasons we put in our letter and the reasons we talked about last week and continue to object, but Your Honor has ruled. Thank you. Finally, we did have the Sandoval hearing last week on Friday, and I will read my ruling from the bench. This court conducted a Sandoval hearing on Friday, April 19th of 2024. At that time, the people disclosed the list of all misconduct and criminal acts of the defendant not charged in the indictment, which the people intended to use at trial to impeach the credibility of the defendant pursuant to CPL Section 245.20, Division 3, Sub A. The people referred to 6 different proceedings involving a total of 13 determinations. The defendant contends, among other things, that prior conduct is too similar to the crime to which he is being charged and will permit the jury to infer guilt from the propensity based on the priors. The court has considered many relevant factors and balanced the prejudice to the defendant against his willingness to advance his own self-interest in reaching the Sandoval compromise. The operative standard is familiar and therefore briefly repeated. It is well settled that the scope and content of cross-examination rests within the sound discretion of the trial judge. That's People v. Sandoval, and then citation here. The court, in exercising its discretion prior to trial, may limit the people's use of the defendant's history of criminal, vicious, and immoral acts to impeach the defendant with cross-examination. Citing Sandoval at 373, the judge balances the act's probative value on questioning the defendant's credibility against the risk of unfair prejudice resulting from their admission. Sandoval at 375. There is no precise formula in determining which prior acts are appropriate impeachment material. People v. Walker, cited from 1994. The trial court's analysis is not bound by the age, nature, or number of the defendant's prior crimes. People v. Gray, cited 84 New York 2nd, 713. A defendant can even be impeached with prior acts or prior bad acts that did not result in a criminal charge. And that's Gray citing Sandoval. All right, let's take everybody. I'm here. I see you. Let's take a poll. Do you all want to see a visual, or would you like to see the full transcript? What I've done in the past is I've done the full transcript, but some people prefer to have a visual of a picture to look at while I'm reading through it. But let's take a poll. Would you prefer to see the transcript? I can pull up the transcript completely if that's what you would prefer. Full, both, full. Either's fine. Full, okay. The visual, no preference. Picture, right. Both. Ah, no preference. Okay, both. All right. All right. So it's good either way. Sure. I'm not sure who's talking. So this is the judge. And one of the reasons why I've pulled the transcript down too is because big chunks of this transcripts are just going to be one person. When we get into the testimony, we'll have a question and answer that'll bounce back and forth. But this right now is just the judge because there's no highlighting here. It's all still just the judge. And then we'll next have the oral arguments and it'll all be the prosecutor, it'll all be the defendant. So we won't have a lot of back and forth with the people. Does that make more sense a little bit? Okay, so good sketch. Yeah, so let's go ahead. Again, I think I would like to leave the sketch up here, but what I would recommend is everyone can kind of go. It's hard to read along. Slide to the right. Okay, yes. Okay, so if you would like to be fully reading along, you can pull up the transcript yourself and just kind of read as I'm going through it as well. I am on page 823. I'm trying to keep the page number in sight for everyone here. Okay. So yes, I think yes. All right, I'm here. I'm catching up. Hello, Tiffany. Great idea. Yes. All right. So feel free, pull up the transcript, everybody, and you can follow the page number at the top right-hand corner, but I will keep a little bit of a visual. Now, again, because we do just have the picture up here, my plan is to go ahead and switch the picture when the person speaking switches. So let me just start here. Let's just get started then. So the person who's speaking, I will put the sketch of that person up then. Can you scoot the sketch up higher? Lots of dead space at the top. Okay, now again, I have multiple screens here, so there we go. Let's see, how about this, everybody? This is, I think, the best I'm gonna be able to get based off of my own screens here. Okay, good, all right, okay. This is the best I can do, everybody. All right, better. Excellent. Paper to the left. I do like to leave the paper. I can't pull it to the left too much or else we will pull the chat, won't be able to read your own comments. Yeah, if I pulled it to the left, I have this blue spot here so we can read the chat, so people can chat as we go through it. Okay. All right, let's go ahead and dive back in. So up here will be the person who's speaking, all right? Here we go, back into it. Indeed, a trial court may exclude such evidence entirely, may alternatively limit inquiry to the mere fact that there has been a prior conviction. It may limit the inquiry to the existence and nature of the prior conviction, or it may permit examination to the facts and circumstances underlying the prior conviction, citing the Hayes case. Thus, even a ruling that permits cross-examination regarding a defendant's entire criminal record does not, without more, indicate an abuse of discretion, citing Walker. In short, the ultimate question as to whether to permit such impeachment is a matter that rests with the trial judge, who exercises a wide range of discretion in ruling on a Sandoval application. That's People v. Contreras. Moreover, as far as probative crimes go, the mere similarity of a defendant's prior conviction or prior conduct to one of the crimes charged does not automatically preclude cross-examination. That's People v. Pavio, P-A-V-A-O, New York, 2nd, 282. That case dealt with violence. The principle was the same. The mere fact that the conduct was similar does not in and of itself preclude going into it. It has long been recognized that a defendant cannot shield himself from impeachment on the basis of frequency of his offense or his tendency to specialize in a particular type of crime. People v. Rahman. It is settled law that a criminal defendant who chooses to testify in his own behalf may be cross-examined about any prior criminal, vicious, or immoral acts that bear logically on his credibility, including those acts by defendant that did not result, again, in a criminal conviction. This court is not required to preclude the people from asking about the incidents because they might keep the defendant off the stand. Yes, yes. Yes. So when we are, right. So the question is make sure to let them know about the court reporter. So, of course, when the judge is citing case law here, he's spelling out the name of the case for the court reporter. So she has some idea, and I don't know actually if it was a she or he. It looks like it was a she based off of the name of Susan, but so that they know how to properly write out the name. So this is a huge courtesy that the judge is doing for his court reporter, and they're very thankful for that. So very, very important. Yes, I do leave the left open just a little bit so we can see our comments here. So this court is not required to preclude the people from asking about the incidents because they might keep the defendant off the stand. People v. Hayes, the Court of Appeals has stated that the alleged singularity of the defendant's testimony does not require the court to limit otherwise appropriate impeachment material. In fact, courts have recognized that if the defendant is the only witness, it may be that much more important that the jury be able to access his credibility accurately. Thus, the possibility, unavailability of other witnesses may cause the trial court to conclude this factor increases the importance of the defendant's credibility. Of course, fairness dictates that the court must be mindful of the potential prejudice to the prosecution in the fact-finding process, denying the jury access to the probative evidence of the defendant's credibility. Citing case law. Finally, any perceived unfair prejudice by a permitted inquiry may be alleviated by the court's careful and specific limiting instructions at the time of cross-examination. And again, during final charge. In fact, the court in clear and forceful language should instruct the jury that they are to consider the defendant's previous conduct only in assessing his credibility, and under no such circumstances are to use his prior conduct as proof that he committed the instant crime. Given those precise instructions which the jurors are presumed to follow, citing case law, the court is permitted to reach a Sandoval compromise. So he has set out what the Sandoval situation is. And again, this is specific to New York, everyone. Upon applying that law, if defendant takes the stand, the court will permit the people to inquire into the following 6 determinations involving 4 separate proceedings. So here's his ruling. First, as to the proceeding of the people by James v. Trump, index number 452564, docket number 1688, the court will allow the people to elicit that on February 16th of 2024, the defendant was found to have violated Executive Law Section 6312 by fraudulently misstating the value of his assets for an economic benefit. The court ordered the defendant to pay penalties and enjoined the defendant from serving as an officer or director of any New York corporation for a period of 3 years. Next, document number 1584, the court will allow the people to elicit that on October 20th, 2023, the defendant violated a court order by failing to remove an untrue, disparaging, and personally identifying post about the court's principal law clerk from the website, donaldjtrump.com. The court fined the defendant $5,000. And the third document from that incident, document number 1598, the court will allow the people to elicit that on October 25th, 2023, the defendant was found to have intentionally violated a court order by making public attacks on the judge's law clerk, despite 2 prior court orders not to do so. The court fined the defendant $10,000. Moving on to the next proceeding, and that would be the Carroll v. Trump case, CV 7311, and that would be ESC number 214. The court will allow the people to elicit that on September 6th of 2023, the defendant was found to have defamed E. Jean Carroll in public statements in 2019 by making false statements with actual malice. As to the next proceeding, that would be Carroll v. Trump, CV 116, and that would be ECF number 174. The court will allow the people to elicit that on May 9th of 2023, the defendant was found to have defamed E. Jean Carroll in public statements made in 2022 on Truth Social by making false statements with actual malice. A jury awarded the plaintiff compensatory and punitive damages. And for the fourth one would be The People by James v. Trump, index 451130 of 2018. The court will allow the people to elicit that on December 11th of 2018, the defendant stipulated to the dissolution of the Donald J. Trump Foundation to resolve claims by the New York Attorney General that he engaged in repeated and willful self-dealing transactions. The court has struck this compromise in order to permit the defendant to testify in his own behalf if he chooses to. In doing so, the court has excluded inquiry to some degree into each of the 6 proceedings, including 2 proceedings that the court will not permit any inquiry at all. Further, the court has greatly curtailed the extent to which the prosecution may inquire into the underlying facts in the specific claims or charges and the amounts of the significant penalties. The court cautions defendant that this Sandoval ruling is a shield, not a sword. After a trial court has made a Sandoval ruling, a defendant who offers misleading testimony about his background and prior conduct opens the door to questioning that otherwise has been excluded, citing case law. Would you like to be heard on this? No. I believe that takes care of all of the preliminary matters. Can we bring the jurors out? Judge, I would like to clarify the record on one point. The Sandoval materials, including the chart, was provided to defense counsel pursuant to your ruling back on March 10th of 2024. Other than that, there's no reason we can't bring in the jury. Okay, let's get the jury, please. Jurors entering. All rise. Whereupon the sworn jury entered the courtroom and were properly seated. Please be seated. Good morning, jurors. Welcome back. Again, this is the judge giving an introduction to the jurors. Members of the jury, we are about to proceed with the trial of the people of the state of New York versus Donald J. Trump. At the outset, I'm going to explain the various stages of a trial and what you may expect to see and hear during the trial so that you may better understand what's taking place. I will also remind you of some basic principles of law which apply to this in all criminal trials. At the conclusion of the case, I will again remind you of those principles. I will define the crimes charged, explain the law that applies to those charged crimes, and list for you the elements that the people must prove beyond a reasonable doubt. These introductory instructions will take about 30 minutes and may sound similar to what you've heard last week. As you can see, a court reporter is taking down everything that's being said. What the court reporter takes down is called the record of the trial. Sometimes you will see a witness use his or her hands to illustrate something. For example, a witness may say that an object was this far away, indicating with their hands. Normally, we will then hear the lawyers or the court say something to the effect of, "Let the record reflect that the witness is indicating about a foot." We do that because sometimes it becomes necessary to have the court reporter read back what the witness has said or what a witness is indicating. If somebody does not say orally for the record that the witness is indicating with his or her hands, when that portion of the record is read back, we may not remember what the witness has indicated. You, of course, will be able to see with your own eyes, and you can make your own judgment. The trial formally begins with what the law calls an opening statement by the prosecutor. The law requires the prosecutor to make an opening statement. The law, however, does not require the defendant to make an opening statement. If the defendant does not make an opening statement, that is not a factor from which you may draw any inference unfavorable to him. Remember that what the lawyers say in the opening statement or at any time thereafter is not evidence. The lawyers are not witnesses. What I say is not evidence. I am not a witness. You must decide this case on the evidence and remember at all times that what the lawyers say at any time is not evidence. After the completion of the opening statements, the prosecutor will proceed with the presentation of evidence. I remind you that the indictment is not evidence. It is simply a document that contains an accusation. The defendant has pled not guilty to those accusations, and a trial is for you to hear in the evidence and whether the defendant is guilty or not guilty, and decide whether the defendant is guilty or not guilty. I remind you also that evidence is the testimony of witnesses, the stipulations, if any, that are agreed to by the parties in documents or other physical objects which are received in evidence. Testimony is, of course, the most common form of evidence and comes from the questioning of witnesses by the lawyers and perhaps by the court. A question by itself is not evidence. It is the question with the answer that is evidence. Sometimes a question will assume, for example, will assume something to be true. You are not, however, to conclude that an assumption in a question is true, unless the answer in your judgment confirms it to be true. So you must consider the question and the witness's answer and decide whether you find the answer believable or inaccurate, because again, it is the question with the answer that is the evidence. Next, evidence may come in the form of a stipulation. A stipulation is information which both parties agree to present to the jury as evidence without calling a witness to testify to that information. Thus, evidence may come in the form of physical items such as documents, photographs, clothing, or charts. When a lawyer is questioning a witness and in the question refers to the physical object for the first time, the object is normally marked with a number or a letter of the alphabet so that we can more easily identify the object and refer to it. The procedure is very helpful in keeping track of physical objects. Sometimes, depending on the type of physical object, it may be too difficult or inconvenient to mark the object, and the object is deemed marked rather than actually marked. Normally, when the object is first referred to, a lawyer will ask the court to have the object marked for identification. If the people make the request and the court grants the request, the object is indeed marked with a number. If the defendant makes a request and the court grants the request, the object is deemed or marked with a letter of the alphabet. It just helps us to remember who introduced the exhibit. Sometimes, to save time during the trial, we will have certain physical objects deemed or marked for identification before the trial begins, and you will then hear the lawyer refer to the object by its number or letter. An item deemed or marked for identification is not evidence and is therefore not available for your inspection or consideration. It's only the objects that are actually received into evidence that are evidence. Sometimes a lawyer will ask the court to receive an object in evidence, and when a lawyer does that, the other lawyer is permitted to ask the witness questions designed to determine whether the object can, under the law, be admitted into evidence. Again, if I grant the request to admit the object in evidence, the object becomes evidence and is available for your inspection and consideration. I advise you that it is common and permissible for a lawyer or an investigator for a lawyer to speak to a witness about his or her testimony before calling him or her to the stand. Also, a witness may review documents and other materials pertaining to the case before he or she testifies at the trial. Generally, a witness scheduled to testify at a trial may not be present in the courtroom during the testimony of other witnesses, but there are exceptions. After the people have completed the presentation of their evidence, the defendant may, but is not required, to present evidence. I remind you that throughout these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty unless, on the evidence presented at this trial, you conclude that the people have proven the defendant guilty beyond a reasonable doubt. That a defendant does not testify as a witness is not a fact from which any inference unfavorable to the defendant may be drawn. The defendant is not required to prove that he is not guilty. In fact, the defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means before you can find the defendant guilty of a crime, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed the crime. Sorry, everybody, tea break. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty. And if the people satisfy their burden of proof, you must find the defendant, page 39, guilty. The law uses the terms proof beyond a reasonable doubt to tell you how convincing the defendant's guilt must be to permit a verdict of guilty. The law recognizes that in dealing with human affairs, there are very few things in this world that we know with absolute certainty. Therefore, the law does not require the people to prove the defendant guilty beyond all possible doubt. On the other hand, it is not sufficient to prove that the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be a reasonable doubt. A reasonable doubt is an honest doubt of the defendant's guilt for which a reason exists based upon the nature and quality of the evidence. It is an actual doubt, not an imaginary doubt. It is a doubt that a reasonable person acting in a matter of this importance would be likely to entertain because of the evidence that was presented or because of the lack of convincing evidence. The proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of a defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed that crime. In determining whether the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of the evidence. After carefully evaluating the evidence, each of you must decide whether the evidence convinces you beyond a reasonable doubt of the defendant's guilt. Whatever your verdict may be, it must not rest on baseless speculation, nor may it be influenced in any way by bias, prejudice, sympathy, or by a desire to bring an end to your deliberations or to avoid an unpleasant duty. Again, if you are not convinced beyond a reasonable doubt that the defendant is guilty of the charged crime, you must find the defendant not guilty of the crime. And if you are convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, you must find the defendant guilty of that crime. Now, when each witness by whomever called is first examined, that is, they are asked questions by the lawyer who calls the witness to testify, that is called direct examination. When the direct examination is completed, the other lawyer is permitted to ask questions of the witness, and that is called cross-examination. The lawyers are responsible for questioning the witnesses. The court may also at times ask a witness a question. The jurors may not ask questions of the witnesses. You may, but are not required to take notes. If you wish to take notes, we will provide materials to you for that purpose. If you decide to take notes, you must follow these rules. Remember, every word of each witness is recorded by the court reporter, and during deliberations, upon your request, the testimony will be read back to you in whole or in part. So there is no need to take verbatim notes of a witness's testimony. Notes, by definition, are a brief written record of something to assist your memory. A note should not take precedence over your own independent recollection. Remember also, you are the finders of fact who are responsible to evaluate the believability and accuracy of a witness's testimony. It is thus important that you be able to both fully comprehend what a witness is saying and how a witness is saying it. Accordingly, you must not permit note-taking to distract you from the proceedings. If you make a note, it should be brief and not distract you from the next question and answer. Any notes a juror takes are only for that juror's own personal use in refreshing his or her recollection. Thus, jurors who choose not to take notes must rely on their own independent recollection and must not be influenced by any notes another juror may have taken. Also, a juror's notes are not a substitute for the recorded transcript of testimony or for any exhibits received into evidence. If during your deliberations there's a discrepancy between a juror's recollection and his or her notes regarding the evidence, you should ask to have the relevant testimony read back or the exhibit produced for your inspection. At the end of each day, you will leave your notes on your chair. They will be collected and safeguarded here. At the end of trial, they will be destroyed. As judges of the fact, you alone determine the truthfulness and accuracy of each witness. You must decide whether a witness tells the truth and was accurate or instead testified falsely or was mistaken. You must also decide what importance to give to the testimony you accept as truthful and accurate. It is the quality of the testimony that is controlling, not the number of witnesses who testified. There is no particular formula for evaluating the truthfulness and accuracy of another person's testimony or statements. You bring to this process all of your varied life experiences. In life, you frequently decide the truthfulness and accuracy of statements made to you by other people. The same factors used to make those decisions should be used in this case when evaluating the testimony. At the end of the trial, I will give you some examples of those factors. There are rules for all stages of the trial, including rules that govern whether certain evidence may be introduced. If so, how and when. Part of my job is to enforce those rules. Some of those rules you may understand the nature of the rule, but some of them you may not understand unless you studied the law. The rules have been carefully developed over hundreds of years for the sole purpose of guaranteeing a fair and orderly trial. In other words, the rules are not designed to determine whether the evidence you hear and see is true or false, accurate or inaccurate. It is for you, not for me, to evaluate the evidence and make those decisions. The rules are designed to ensure that the evidence you hear and see is relevant and in a form that permits you to evaluate it fairly. A witness usually can testify only about matters the witness has personal knowledge of. That is, something the witness has personally seen, heard, felt, touched, or tasted. Thus, a witness is not permitted to guess or speculate or say he or she thinks another person saw, heard, felt, touched, or tasted. Also, a witness is not permitted to give an opinion about matters for which a special expertise is necessary, unless, of course, the witness purports to be an expert on the matter he or she is being questioned about. And then here we go. We have the court reporter who was replaced at this point. So at this point, this court reporter was relieved. So there was a little break here. Now we have just one more page here of his opening. Actually, let me double check. We may have instructions at this point. Let's see. Okay, let me go ahead and go through this. This is really important, this piece. And then I will go ahead and skip through and get to the first opening statement after this. So here we go. With some exceptions, what a witness may have been thinking when something else has taken place is not relevant evidence. Finally, a witness is often not permitted to testify to hearsay, meaning generally that a witness cannot testify to what the witness may have said before trial or what another person may have said to that witness before the trial. But there are many exceptions to the hearsay rule for a variety of sound reasons, too numerous to go into at this time. There's 27. I will, however, explain a couple of the exceptions that frequently arise during a trial. Sometimes a witness will be permitted to testify that a witness did something because of what someone said in the circumstance. It does not matter who uttered the statement or how the speaker gathered the information for the statement, or even whether the statement is truthful or accurate. It matters only that someone uttered the words and the witness did something upon hearing those words. So in that instance, you may not conclude that the witness was told for the truth of the words said to the witness. You may consider the words only for the reason that they were offered, that is, to explain what the witness did after hearing the statement. That would be called an excited utterance exception. So with that, I will go ahead and skip through until we get to the next opening statement, everyone. The judge does go on a little bit further here to just kind of set out what those opening statements are and that he's requesting the jury to listen. Now, I would like to spend more time on this, but for tonight, we're already kind of running a little bit low on time. So I think it would be better to go ahead and start our opening statements, okay? Here we go. And this is the court here, and then we will get into the people's opening statement. Having concluded my preliminary instructions, I will now ask the people to deliver their opening statement. People. And then, of course, because we are in New York, we are known as the people of the state of New York. In other states, we're just known as the state or the Commonwealth. It depends on where you're at. All right, everyone. After those introductory remarks, I will go ahead and just dive in to the opening statement that was given here. All right, here we go. Good morning, Your Honor, counsel, members of the jury. This case is about a criminal conspiracy and a cover-up. The defendant, Donald Trump, orchestrated a criminal scheme to corrupt the 2016 presidential election. Then he covered up the criminal conspiracy by lying in his New York business records over and over and over again. In June of 2015, Donald Trump announced his candidacy for president in the 2016 election. A few months later, this conspiracy began. He invited his friend, David Pecker, to a meeting at Trump Tower here in Manhattan. Mr. Pecker was the CEO of a media company that, among other things, owned and published the National Enquirer tabloid. Michael Cohen was also at that meeting. He worked for the defendant as the defendant's special counsel at his company, the Trump Organization. And those three men formed a conspiracy at that meeting to influence the presidential election by concealing negative information about Mr. Trump in order to help him get elected. As one part of that agreement, Michael Cohen paid $130,000 to an adult film actress named Stormy Daniels, just a couple of weeks before the 2016 election, to silence her and make sure the public did not learn of the encounter with the defendant. There are certain words I will not be saying, everyone. This is one of them. Cohen made that payment at the defendant's direction, and he did it to influence the presidential election. After the election, the defendant then reimbursed Cohen for that payment through a series of monthly checks, all of which were processed through the defendant's company, the Trump Organization, and they disguised what the payments were for. The defendant said in his business records that he was paying Cohen for legal services pursuant to a retainer agreement, but those were lies. There was no retainer agreement. Cohen was not being paid for legal services. The defendant was paying him back for illegal payment to Stormy Daniels on the eve of the election. The defendant falsified those business records because he wanted to conceal his and others' criminal conduct. In total, the defendant falsified 34 business records to cover up the criminal conspiracy. As a result of his conduct, the defendant was indicted by a grand jury in Manhattan of 34 counts of falsifying business records. And the first count of that indictment reads, "The grand jury of the County of New York, by this indictment, accuses the defendant of the crime of falsifying business records in the first degree in violation of Penal Law Section 175.10, committed as follows. The defendant in the County of New York and elsewhere on or about February 14th of 2017 with intent to defraud and intent to commit or conceal another crime and to aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an invoice from Michael Cohen dated February 14th of 2017, marked as a record of the Donald J. Trump Revocable Trust and kept and maintained by the Trump Organization." Now, the remaining 33 counts in this indictment detail the rest of the false business record charges for each monthly payment. The fraudulent cover-up scheme involving falsifying 3 different types of business records: an invoice falsely describing a request for payment for legal services rendered in a given month, a voucher entry in the Trump Organization's general ledger system falsely describing the payment as one for legal services, and a payment checks with the check stubs that also falsely described the nature of payments. All in all, the defendant disguised his payments to Michael Cohen through 11 falsified invoices, 12 falsified ledger entries, and 11 falsified checks for a total of 34 false business records in the books and records of his company, the Trump Organization. But, as Judge Mershon told you, the indictment is not evidence. So let's talk about what the evidence will be. It starts with that August 2015 meeting in Trump Tower. The defendant had just announced he was running for president, and he asked David Pecker to come to Trump Tower to talk. At the time, David Pecker was the chairman and CEO of a major media company called American Media Incorporated, or AMI. AMI owned and published celebrity magazines, health and fitness magazines, and supermarket tabloids like the National Enquirer. As the man in charge of AMI, Pecker had the ultimate say over publication decisions. He had the say over what stories to publish or not publish in any of AMI's magazines or tabloids. And Trump and Pecker were joined at that meeting by Michael Cohen, who, as I mentioned, worked for the defendant at the Trump Organization and served as special counsel to the defendant. Now, Cohen's job really was to take care of problems for the defendant. You will hear evidence at trial that he was even referred to as Trump's fixer. So those three men, Donald Trump, David Pecker, and Michael Cohen, struck an agreement at that meeting together. They conspired to influence the 2016 presidential election in 3 different ways. First, they agreed that Pecker would help the defendant's campaign by acting as eyes and ears for the campaign. Pecker could use AMI's network of sources through all of its magazines and publications to gather information that might be harmful to Trump's candidacy, report that information to Cohen, so Donald Trump would then prevent the information from becoming public. Second, they agreed that AMI would use its tabloids and magazines to publish flattering stories about the defendant. And third, they agreed that AMI would use those same publications to attack Mr. Trump's political opponents. After the meeting, David Pecker told the National Enquirer's editor-in-chief, a man named Dylan Howard, to report directly to Pecker about this Trump Organization conspiracy, and he enlisted his help in carrying it out. And together, those co-conspirators then followed through on every aspect of this scheme I just described. So, for example, the National Enquirer ran headline after headline that extolled the defendant's virtues, headlines that Mr. Pecker specifically directed his publication to make because of the conspiracy he reached at the Trump Organization agreement. Many of those headlines and stories behind them were even shown to Cohen and the defendant in advance before they were published, so the defendant could review them, request changes, accept or reject publication stories, even cover art. The National Enquirer also ran stories attacking Mr. Trump's political opponents. You will see evidence of those stories at trial. They include tabloid headlines and stories attacking one of his political opponents, Dr. Ben Carson, accusing him of medical malpractice. They ran another story attacking a then candidate named Senator Ted Cruz, accusing him of some kind of infidelity, accusing him of having some family connection to the JFK assassination. The National Enquirer ran these stories as part of that conspiracy that was launched at the Trump Tower meeting, and they did it to help the defendant's campaign. And after some of these stories came out, the defendant even followed up with his contacts at AMI to thank them for the stories and to praise them for their attacks. In their publications on his political opponents. So you had 3 parts of this conspiracy. You had the agreement to run positive coverage, you had the agreement to attack his opponents, and then the core of the conspiracy was David Pecker's agreement to act as eyes and ears for the campaign in an effort to locate damaging information about the defendant and then take steps to try to bury it to help Mr. Trump get elected. It was a core part of this conspiracy that the co-conspirators then executed through 3 different transactions over the course of the next year. They used a practice called catch and kill. Catch and kill is when the tabloid buys up damaging information about someone, demands that the source sign a non-disclosure agreement to prevent them from taking that information or that story anywhere else, and then the tabloid declines to publish the story to prevent it from ever seeing the light of day. So it's a way of buying damaging information, not to publish it, but to hide it, make it go away, and in this case, to help the candidate. Now, Trump and Pecker and Cohen carried out 3 different catch and kill deals to help him get elected. First, just a few months after the Trump Tower meeting, David Pecker learned that a former Trump Tower doorman named Dino Sajidin was trying to sell information about an alleged out-of-wedlock child that Trump had fathered with one of his former housekeepers. So, as they agreed at the Trump Tower meeting, Pecker immediately contacted Cohen with that information. Cohen then told the defendant, Donald Trump, who told Cohen to take care of it. After consulting with Cohen, Pecker directed Howard, his editor-in-chief at the National Enquirer, to negotiate an agreement to pay $30,000 to Sajidin to buy the exclusive rights to his story. And the evidence will show that Pecker was not acting as the publisher. He was acting as a co-conspirator. The evidence will show that this was a highly unusual deal. Even for tabloid journalism, it was a lot more money than they would usually pay to a source. They bought Sejdić's story without even fully investigating it, and it was the first time that David Pecker had ever paid anyone for information about Donald Trump. But Pecker directed that deal take place because of the agreement he had reached, and because he had promised Donald Trump at the Trump Tower meeting in August of 2015 that he would use his media empire to help the defendant's campaign. And they knew the public disclosures of Sejdić's information would hurt that campaign. Michael Cohen even coordinated with AMI throughout the whole process and insisted that AMI amend the agreement with Mr. Sejdić after it was signed to add a $1 million damages penalty fee if Sejdić violated the confidential agreement. So, you have the candidate's fixer actively colluding with a catch-and-kill deal with the media enterprise by adding deal terms to lock up the negative information even tighter to keep it from coming out before the election. And when AMI later determined that Mr. Sejdić's allegations weren't even true, Cohen told Pecker not to release Sejdić, not to release him from his NDA until after the presidential election. And because of the agreement that they had reached, Pecker did what Cohen said. Pecker deliberately delayed releasing Sejdić from his non-disclosure agreement with AMI until after the November 2016 election, when it could no longer hurt Trump's candidacy. So that was just the first of 3 catch-and-kill deals that I mentioned that came out of the Trump Tower conspiracy. Dun, dun, dun. The second involved a woman named Karen McDougal, a former Playboy playmate. About 5 months before the presidential election in June of 2016, Dylan Howard of the National Enquirer heard from one of his frequent sources, a lawyer named Keith Davidson. Davidson was representing Ms. McDougal and was shopping around her account of her affair with Mr. Trump. Davidson told Howard that he had, quote, a blockbuster Trump story. Karen McDougal said that she had had a romantic and this kind of relationship with the defendant while he was married that lasted nearly a year. So, as David Pecker had tasked him at the Trump Tower meeting, Howard got in touch with Cohen, the Trump organization, right away and told him that he had learned what he had learned, and Cohen then told the defendant, and the evidence will show the defendant desperately did not want this information about Karen McDougal to become public because he was concerned about its effect on the election. And at David Pecker's direction, Howard flew to California. He met with Karen McDougal and her lawyer, Keith Davidson, in person. Before the meeting, during the meeting, after the meeting, Howard and Pecker were in the frequent and urgent contact with Michael Cohen, who wanted updates on the progress of their discussions. You're going to see the flurry of text messages and the barrage of phone calls around those conversations and around that meeting. And when Howard called Cohen after the meeting with Karen McDougal, Howard said he thought the allegations were true. So Cohen asked AMI to make arrangements to buy McDougal's information quickly so that they could prevent anyone else from publishing it. Trump and Pecker and Cohen, they had a series of conversations and discussions about who would put up the money for that payoff deal. Pecker ultimately agreed that he would have AMI make the $150,000 payment to McDougal in exchange for the limited life rights to the story of her affair. To provide some cover for that payoff, AMI added other terms to the deal. Miss McDougal would appear on the magazine's covers. With the help of a ghostwriter, they would run lifestyle articles under her name in other AMI magazines. But the real reason Pecker directed AMI to make this payment to McDougal was to make sure she didn't publicize her account of her affair with Trump before the 2016 election. David Pecker will also testify that $150,000 was way more than AMI would ordinarily pay for this type of story. But he discussed it directly with Donald Trump, and he discussed it with Michael Cohen, and he agreed to the deal on the understanding that Trump was going to find a way to pay AMI back. You will hear David Pecker testify about his conversations with Donald Trump about the McDougal payoff. And 3 months before Election Day, AMI and McDougal signed that deal. But as the weeks dragged on and the defendant hadn't yet made good on his agreement to pay AMI back, Pecker started getting antsy and he was frustrated, and he said so to Michael Cohen. So to show Pecker that Trump really did plan to pay AMI for the McDougal payoff, Cohen used his cell phone to record a conversation with Donald Trump on September of 2016. You will get a chance to hear that recording during this trial. On that tape, Cohen tells the defendant that he will create a company to buy up McDougal's story from AMI. Cohen tells the defendant that he spoke to, Cohen tells the defendant that he spoke to Alan Weisselberg, who is the Trump Organization chief financial officer, about how to set the whole thing up. And on that recording, you will hear the defendant in his own voice. You will hear him ask Cohen, so, I can't do it, everybody. I can't do Trump's voice. So, what do we got to pay this for? $150? You will even hear Mr. Trump suggest in his own voice, you will hear him suggest paying in cash. After that conversation, Cohen then proceeded to set up a shell company for the transfer. It was less than 6 weeks to Election Day, and Cohen then worked out a deal with David Pecker for AMI to sell its rights to the McDougal story to Cohen's shell company. That way AMI would get paid back, and Trump would then own the rights to the McDougal story. Just as Cohen was doing, Pecker also used a middleman to hide the true nature of the transaction. He agreed to have another company put together a fake invoice billing Cohen's shell company for so-called advisory services. Trump would become the new owner of Miss McDougal's story. But to any observer looking at those records, neither Pecker nor Trump would even appear as parties to the transaction. After the agreement was signed, but before any money changed hands, David Pecker consulted with AMI's general counsel. And based on that conversation, Pecker got cold feet. He told Cohen that the deal was off, that the deal to transfer the rights to Cohen's shell company was off, and AMI would instead eat the cost of the payment off McDougal. So that's the second catch and kill deal that came out of the Trump Tower agreement. You will see all of that evidence. You will see AMI learned about a blockbuster Trump story about a Playboy Playmate's extramarital affair with Donald Trump. The company coordinated directly with the candidate to pay her off, to help the campaign by keeping her quiet just months before the election. You will see the company not only made that corporate contribution, but it falsified other corporate records to hide the details of the deal. And you will hear the defendant's own voice on the tape in a recorded conversation working out the intention for payment. Next, about a month before the election, the Washington Post published a news story on video, which the evidence will show turned the rest of the presidential campaign entirely upside down. On October 7th of 2016, the Post published a video of Donald Trump caught in a hot mic on the set of a television show called Access Hollywood. He didn't know he was being taped, and you will see an email that the Washington Post reporter emailed to the campaign's press secretary, Hope Hicks, a few hours before the story ran. And they sent her a transcript of the Access Hollywood tape, and the transcript depicts Donald Trump bragging about assault. It depicts, and I'm quoting the defendant's word from the transcript, that you will see in this trial, quote, I'm automatically attracted to beautiful women. I just start kissing them. It's like a magnet. Just kiss. I don't even wait. And when you're a star, they just let you do it. You can do anything. Blah, 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 end quote. Those were Donald Trump's words on a video that was released 1 month before Election Day. And the impact of the tape on the campaign was immediate and explosive. Prominent allies withdrew their endorsements. They condemned Donald Trump's language. You will hear testimony that the Republican National Committee even considered whether it was too late to replace their own nominee and find another candidate for election a month before Election Day. Thanks, Matt. The defendant and his campaign staff were deeply concerned that the tape would irreparably damage his viability as a candidate and reduce his standing with female voters in particular. And they knew it was damaging not only because Trump bragged about assault, they knew it was damaging not only because the language on the tape was crude and vulgar. The campaign was also worried about the damage the tape would cause precisely because it was on video, seeing and hearing a candidate in his own words. Check for your puzzle piece. Yes, I've got one eye on the puzzle piece. Thanks, BC. I appreciate that. In his own voice, in his own body language, his own gestures has a much greater impact on voters than words on paper. So the campaign went into immediate damage control mode to blunt the impact of the tape. Now the defendant's initial public response to the Access Hollywood tape was to call it locker room talk. He told voters it was just words, not behavior, and that's the context to what happened next. One day after the Access Hollywood tape was released, Dylan Howard, he's the National Enquirer's editor-in-chief, told David Pecker that another woman had come forward with the claim of an encounter that she had had with the defendant while he was married. The woman was an adult film actress, a porn star named Stormy Daniels. As Pecker had promised and as they had done for the last year, Howard got in touch with Michael Cohen at the Trump Organization immediately. Howard told Cohen about the story. He connected him with Stormy Daniels' lawyer, Keith Davidson, the same lawyer who had represented Karen McDougal. And Cohen then discussed the situation with Trump, who was adamant that he did not want the story to come out. Another story about infidelity, especially with a porn star on the heels of the Access Hollywood tape, could have been devastating to his campaign. So at Trump's direction, Cohen negotiated a deal to buy Miss Daniels' story in order to prevent American voters from learning that information before Election Day. Under the deal, another non-disclosure agreement, Daniels agreed that she would not disclose the encounter in exchange for a payment of $130,000. But Trump directed Cohen to try to delay finalizing the deal, to delay making the payment as long as possible, while also at the same time preventing Daniels from publicizing the story. His hope was to delay it until after the election and then not pay at all. And Cohen was able to put it off for a time with a series of excuses. But Daniels and her representatives figured out that they were being strung along. It became clear that the story would become public if the deal wasn't finalized immediately. So with the pressure mounting and Election Day fast approaching, Donald Trump agreed to the payoff and directed Cohen to proceed. Cohen tried several times to get Pecker to agree to pay for this catch and kill deal, but Pecker was unhappy that he had never been paid back for the Karen McDougal deal or for a Sigident deal. He was still willing to use AMI's resources to help close the deal so long as someone else put up the money. So Cohen discussed other payment options with Trump and Alan Weisselberg, the chief financial officer of the Trump Organization. And Trump didn't want to write a check himself to make the $130,000 payment. So he asked Cohen and Weisselberg to figure out some other way to make the payment. And after discussing different possibilities with Weisselberg, they agreed that Cohen would make the payment through a shell company to make it harder to track. But before putting up his own money, Cohen confirmed with Trump that Trump would pay him back, and at Trump's request, Cohen agreed to lay out his own money for the payment to keep Stormy Daniels quiet. 2 weeks before the presidential election, on the morning of October 26th of 2016, Cohen made 2 phone calls to the defendant to confirm he was finalizing the arrangements. You will see the telephone records of those calls. Then Cohen walked across the street. He opened a bank account in the name of a new shell company called Essential Consultants, LLC, which was created to carry out the Stormy Daniels payoff. He then transferred $131,000 from the home equity line of credit on his own home into the shell company's bank account. The next day, Cohen wired $130,000 to Stormy Daniels' lawyers to keep her quiet. And as part of their efforts to try to keep the entire scheme under wraps, Cohen gave false information to the banks about the shell company's business purposes in the account opening forms he was required to complete and in the wire transfer records that he filled out describing the purpose of the $130,000 payment. Cohen made that payment at Donald Trump's direction and for his benefit, and he did it with a specific goal of influencing the outcome of the election. Now, look, no politician wants bad press, but the evidence at the trial will show that this was not spin or communication strategy. This was a planned, coordinated, long-running conspiracy to influence the 2016 election, to help Donald Trump get elected through illegal expenditures, to silence people who had something bad to say about his behavior, using doctored corporate records and bank forms to conceal those payments along the way. It was election fraud, pure and simple. We will never know, and it doesn't matter if this conspiracy was the difference maker in the close election, but you will see evidence in the defendant's own words from his social media posts, from his speeches at campaign rallies and other events. You will see in his own words making crystal clear that he was certainly concerned about how all of this would hurt his standing with voters and with female voters in particular. Thank you, Sarah. Tea break, everyone. I don't know, there's such a crescendo here. It's hard to remember to take a break. You will also see evidence that on election night, as news outlets got closer to calling the election for Donald Trump, Keith Davidson, he was the lawyer for both Stormy Daniels and Karen McDougal, texted Dylan Howard at the National Enquirer and he said, quote, "What have we done?" And about a month after the election, Pecker then authorized AMI to release both Sugden and McDougal from their non-disclosure agreements. So having paid for the stories in order to keep them from the public before Election Day, Pecker and AMI then told both McDougal and Sugden a month after the election that they were no longer bound by this non-disclosure agreement. In January of 2017, Pecker met again with Donald Trump. This was before Mr. Trump was inaugurated. He was still working primarily from Trump Tower here in Manhattan, and they met privately in Trump's office. The defendant thanked Pecker for handling the McDougal and Sugden stories, and he invited him to the inauguration. And that summer, the defendant invited Pecker to the White House. Pecker brought his eyes and ears, Dylan Howard from the National Enquirer, to that dinner. And the defendant hosted a thank you dinner to thank Pecker and AMI for their contributions to his campaign. There were a few other loose ends to deal with after the election. One was figuring out how Michael Cohen was going to get paid back for the Stormy Daniels payoff. In January of 2017, before the defendant moved down to Washington to begin his presidency, Cohen met with Alan Weisselberg to talk about how Cohen was going to get reimbursed for the payoff to Ms. Daniels. Weisselberg, you will remember, was the Trump Organization chief financial officer, and he was one of the defendant's longest-serving and most trusted employees. Neither Trump nor the Trump Organization could just write a check to Cohen for $130,000 with a memo line that said reimbursement for porn star payoff. They had to disguise the nature of the repayment, so they agreed to cook the books and made it look like the repayment was actually income, payments for services rendered, instead of for reimbursement. Weisselberg asked Cohen to bring a copy of a bank statement for the Essential Consultants account showing the $130,000 payment that Cohen had made to keep Daniels quiet before the election. Weisselberg and Cohen agreed to a total repayment amount of $420,000. And here is how they got to that number. They started with $130,000 that Trump owed Cohen for the Stormy Daniels payoff. Then they added $50,000 for a separate reimbursement Cohen was claiming, which had to do with tech services he paid during the campaign. That adds up to $180,000. Then they agreed to double that amount to $360,000 to account for taxes. Now, of course, if Trump was just reimbursing Cohen, there was no need to gross it up for taxes. They doubled it because their plan was to call it income instead of reimbursement. And if Cohen was getting money they were calling income, they would have to pay taxes on it. Cohen was close to a 50% tax bracket when you consider federal and state and city tax. So to make him whole on the $180,000 that the defendant owed him, they had to double the amount to $360,000. Then he had to add another $60,000 as a year-end bonus. And all of that comes to a total of $420,000. And Alan Wesselberg wrote all of that down. The bank statement that I told you about that he asked Cohen to bring to their meeting, the bank statement from the Essential Consultants LLC account, which showed the $130,000 wire that Cohen had made to Keith Davidson to keep Stormy Daniels quiet, you will see in this trial Alan Wesselberg's handwriting down the side of that bank statement, laying out every one of the steps that I just described, showing how they converted the $130,000 payoff amount to the $420,000 that Cohen was going to get paid back as a grossed up way to disguise it, not as a reimbursement, but as income. Cohen and Wesselberg then met with Trump, who approved the repayment amount of $420,000 on the $130,000 Stormy Daniels payment and a few other expenses. Now you will see the evidence at trial that Donald Trump was a very frugal businessman. He believed in pinching pennies. He believed in watching every dollar. He believed in negotiating every bill. It's all over the books he has written. He ran the Trump Organization with total control. You will hear testimony about his relentless focus on the bottom line. But when it came to pay Michael Cohen back for the catch and kill deal, you will see he didn't negotiate the price down, he doubled it. And he doubled it so they could disguise it as income. And you will hear evidence that the Trump Organization was not in the practice of paying people twice what they owed for anything. This might be the only time that ever happened. And Donald Trump's willingness to do so here shows just how important it was to him to hide the true nature of Cohen's illegal payment to Miss Daniels and the overall election conspiracy that had launched in August of 2015. When Cohen and Wesselberg met with the defendant to agree on the doubled up reimbursement amount, they decided they would pay it back in a series of monthly payments over the course of the entire year of 2017. Now, $420,000 spread over 12 payments comes out to $35,000 a month. You will see that the calculation in Alan Wesselberg's handwriting notes too. So the defendant and Cohen and Wesselberg agreed that every month Cohen would send a bogus invoice to the defendant through the Trump Organization, falsely requesting payments of $35,000 for legal services rendered in a given month of 2017 pursuant to a retainer agreement. That was a double lie. There was no retainer agreement. Cohen was not getting paid for legal services rendered in 2017. It was instead what they thought was a clever way to pay Cohen back without being too obvious about it. And in early February of 2017, Cohen went down to Washington and he met with the defendant at the White House. Dun, dun, dun. What's going to happen? I think we all know. Oh, goodness. And they confirmed that repayment arrangements. We're going to show you at trial a photo of Cohen at the White House for that meeting. And a few days later, after they met and confirmed the whole plan, Cohen sent the first of his fake invoices to the Trump Organization. And a few days after that, Cohen got his first reimbursement check. In total, Cohen submitted 11 phony invoices by email to the Trump Organization here in Manhattan so the defendant could pay him back. Each invoice repeated the lie that Cohen and defendant had agreed on in advance, that Cohen was requesting payment for legal services pursuant to a retainer agreement, which didn't exist. Through these false business records, the defendant intended to make sure that nobody learned about the Stormy Daniels payoff and the illegal election fraud scheme launched at the Trump Tower meeting in 2015. Sorry, tea break, everyone. The defendant's accounting staff at Trump Tower here in Manhattan then processed every one of those invoices as business records of the Trump Organization and retained them in the Trump Organization's files. The accounting staff recorded the reimbursement in their general ledgers, falsely as legal expenses with a description of a retainer. The accounting staff then prepared checks that each included the description retainer. The checks were stapled to bogus invoices for approval and signature. The first two checks were paid from a trust the defendant had created called the Donald J. Trust, the Donald J. Trump Revocable Trust, which held all of the Trump Organization's assets after he became president. The defendant was the beneficiary of that trust. Each of the remaining checks that were issued over the course of 2017 were paid from the defendant's own bank accounts. And the defendant signed those checks, each of them himself, while he was president. And the Trump Organization maintained all of those records: the false invoices, the vouchers with false entries, the checks with the check stubs with false entries at Trump Tower here in Manhattan. And with the final payment in December of 2017, the defendant had repaid Cohen the full $420,000 they had agreed upon, and the monthly payments stopped. Now, during this trial, you will hear a lot about Michael Cohen. I suspect the defense will go to great lengths to get you to reject his testimony precisely because it is so damning. You will learn, and we will be very upfront about it, the fact that Michael Cohen, like other witnesses in this trial, has made mistakes in his past. For example, Cohen will tell you that the truth about the payoff to Stormy Daniels first began to come to light in 2018. He lied. He lied about it to protect his boss. You will also learn that Michael Cohen has a criminal record. He will testify that in April of 2018, the FBI raided his residence and his offices as part of an investigation that included potential violations of federal campaign finance law. Cohen will also testify in this trial that he ultimately pled guilty and went to jail for causing an unlawful corporate contribution in connection with the Karen McDougal payments and for making an excessive campaign contribution in connection with the Stormy Daniels payoff. Whereupon the senior reporter, Lisa, is relieved, and the senior court reporter, Lori, and the transcript continues on the following page. I got to replace our reporter here. Here we go. He also pled guilty to and served time for tax crimes and lying to a bank and lying to Congress. And you'll also learn that Cohen has publicly committed to making sure the defendant is held accountable for his role in this conspiracy. The evidence will also show why you can credit Michael Cohen's testimony despite those past mistakes. As we discussed in jury selection, you will need to keep an open mind and carefully evaluate all of the evidence that corroborates Michael Cohen's testimony and the testimony of all of the witnesses. Cohen's testimony will be backed up by testimony from other witnesses you will hear from, including David Pecker and Keith Davidson. It will be backed up by an extensive paper trail of bank records, emails, text messages, phone logs, business documents, and other records that we will show you sometimes at length during this trial. And it will be backed up by Donald Trump's own words on tape, in social media posts, in his own books, and in a video of his own speeches. Now, as I said when I started, this case is about a criminal conspiracy and a cover-up, an illegal conspiracy to undermine the integrity of a presidential election, and then the steps that Donald Trump took to conceal that illegal election fraud. At the end of this case, we're confident that you will have no reasonable doubt that Donald Trump is guilty of falsifying business records with the intent to conceal an illegal conspiracy to undermine the integrity of a presidential election. And as you credit all of the evidence the people will present, we ask you to use your common sense. Look past any distraction. Look past any irrelevant sideshows that may pop up during this trial. Tune out the noise. Focus on the facts. Focus on the logical inferences that follow from those facts. Focus on the evidence. Listen to the testimony, read the documents, the emails, the text messages, and the bank statements, the handwritten notes, all of it. And after all of that evidence is in, we'll have a chance to speak to you again during closing arguments. My colleague Joshua will go through all of the evidence and explain that it inescapably leads to only one conclusion: Donald Trump is guilty of 34 counts of falsifying business records in the first degree. Thank you, Mr. Coliangio. Counsel. All right, everyone. That's the end of the opening statement for the state. We will move on into the opening statement for defense. We must have both sides. So here we go. Let me just get it set up. Yay! Now it's going to have a little bit different tone for Mr. Blanche. Oh. All right, just one moment. Oh, thank you so much. Thank you. I appreciate it. All right, here we go. Here we go. Here we go. Now this is going to start at the bottom of the page, so you're not going to see it here at the top. I am keeping the page number in frame. Oh, thank you so much, everybody. So we're starting at the bottom of the page. Good morning. Good morning, Your Honor. Good morning. President Trump is innocent. President Trump did not commit any crimes. The Manhattan District Attorney's Office should never have brought this case. You've heard this a few times already this morning, and you're going to hear it a lot more during this trial. The people, the government, they have the burden of proof to prove President Trump guilty beyond a reasonable doubt. What that means, as Judge Merchan said a few minutes ago, is that President Trump is presumed innocent. He's cloaked in innocence, and that cloak of innocence does not leave President Trump today. It doesn't leave him at any day during this trial, and it won't leave him when you all deliberate. You will find that he is not guilty. Now, President Trump, you've seen him, of course, for years and years and years. You've seen him on television. You've seen photos of him. You've seen articles written about him. He's in some ways larger than life, but he's also here in this courtroom doing what any of us would do, defending himself. After paying a porn star. Sorry. Apologize. My bad. You're going to hear me, as I've done already today and others, even witnesses, refer to him as President Trump. This is a title that he's earned because he was our 45th president. We will call him President Trump out of respect for the office that he held from 2017 to 2021. And as everybody knows, it's the office he's running for right now. He's the Republican nominee. But, and this is important, he's not just our former president. He's not just Donald Trump that you've seen on TV and read about and seen in photos. He's also a man. He's a husband. He's a father. And he's a person just like you, just like me. What the people just did for about 45 minutes is present to you what appeared to be a very clean, nice story. It's not simple as the people just described. For one, and you heard the people admit this, most of what you're going to hear about in this trial, most of the conversations, most of the documents are from 2015, 2016, 2017, years and years ago, pre-COVID. And you're going to hear witnesses talk about conversations, meetings, people they met from 2015. The story that you just heard you'll learn is not true. And at the end of this trial, there will be plenty of reasonable doubt. Here's what I expect that you will learn happened. President Trump for years built a very large, successful company. He employs thousands of people. It's a purely private company, not like AT&T or FedEx, publicly traded. And when he became president in 2017, he put up a wall between himself and his company, as the people just alluded to. He put his entire company in a trust. He did this so he could run the country, and he wouldn't have anything to do with his company while he was president. But some of his employees, you'll learn, continued to help record personal expenses that President Trump incurred while he was president. Not surprising. They have been doing that for years. You'll hear that they're still doing that today. So, when President Trump became president, when he took the office of the presidency in 2017, in January, Michael Cohen, who you heard the people allude to, assumed the role of President Trump's personal attorney. And you will learn that each month in 2017, Michael Cohen sent an invoice to some of the employees at the Trump Tower right here in Midtown for $35,000. And on this invoice, Michael Cohen described his work as, quote, payment to the retainer agreement for legal services rendered, end quote. The invoice was processed. Somebody at Trump Tower generated a check. The check was ultimately signed, and there was a record in a ledger of President Trump's personal records that reflected the invoice. For 9 of the checks, the check made its way down to the White House, and President Trump signed it. You'll hear what he's the only signatory on his personal checking account, which is why he signed the check. So, what on earth is a crime? What is a crime about what I just described? This business records violation from the people have brought against President Trump. The 34 counts, ladies and gentlemen, are really just 34 pieces of paper and 34 counts of the invoices that Mr. Cohen sent to the folks at Trump Tower. The checks that were generated because of that invoice, and then the ledger notation from the invoice that said for retainer agreement and legal services. None of that was a crime. Now, you've just heard the people's theory about that $35,000, that it really wasn't a monthly retainer, that Michael Cohen was actually trying to cover up with President Trump the payback of this $130,000 payment to Stormy Daniels, who also goes by Miss Clifford, Stephanie Clifford. You'll hear that Miss Clifford, Miss Daniels, did in fact sign an NDA in October of 2016 in exchange for $130,000. But think for a moment of what the people just told you. President Trump did not pay Mr. Cohen back $130,000. President Trump paid Michael Cohen $420,000. And in the same breath, the people told that President Trump is known as a frugal businessman, that he pinches pennies. Ask yourself, would a frugal businessman, would a man who pinches pennies repay $130,000 debt to the tune of $420,000? More significantly than that, ladies and gentlemen, you're going to learn that this was not a payback. This $35,000 a month was not a payback to Mr. Cohen for the money he gave to Miss Daniels. He was President Trump's personal attorney. You will see documents, you will see emails. His signature block, Michael Cohen's signature block in 2017 said Michael Cohen, personal attorney to President Donald Trump. You will hear that he told the people that he served as President Trump's personal attorney. You will hear that he did legal work for President Trump and that the First Lady as his personal attorney. Now, the people talk about the ledger. I mentioned the ledger a few times. Listen, the ledger's just a fancy way of describing how folks at Trump Tower, employees that work for President Trump, kept track of the money that came in and the money that went out. There's nothing fancy about a ledger. It's something, I suppose, like a checkbook where you keep track of what you're spending money on. And I expect that you'll learn that the record, the ledger that was used in this case that President Trump is charged with, that the information that was placed in the ledger was done by someone named Ded Tarasoff. I expect she will testify. You will hear that she's a woman who has worked for President Trump for decades. Nobody's going to say she did anything wrong. I don't expect the people will say she is a part of this scheme. What she will tell you is she had a conversation with another boss, someone who she worked with, another accountant, someone who has nothing to do with this, and she was told when she got the invoice from Mr. Cohen to call it legal expense, which is exactly what the invoice said, and that's exactly what she did. And then after recording it, she generated a check, which was her job. And then again, for 9 of the 11 checks, the checks made their way from Trump Tower here to Midtown, to 230 miles down south to the White House where they were signed. Need puppet nails. But, and you heard this again from the people, I'm not saying anything controversial. President Trump had nothing to do with the invoice, with the check being generated, or with the entry on the ledger. Ms. Tarasoff isn't going to say that she had any conversations with President Trump. Hey, how should I book this? How should I book this? Keep it secret and keep it quiet? The invoice says it's for services rendered, and it's Michael Cohen. He's a lawyer. He worked for the Trump Organization, you'll learn, for many years. You won't hear any of that. Her boss, the person who told her how to book it, he's not going to say he talked to President Trump about it. He's not going to say he called the White House and interrupted a meeting as President Trump was running the country and said, hey, we got this invoice. I know you're trying to cover it up here. Absolutely not. You'll learn President Trump had nothing to do with any of the 34 pieces of paper, the 34 counts, except he signed on to the checks. In the White House, he was running the country. That's not a crime. So, and some of you heard this last week during jury selection, what are the people going to do? I don't expect they're going to dispute what I just said. I don't expect that they're going to call a witness that says that President Trump had anything to do with what was written on the ledger, with generating the check, with the invoice coming in. So you heard last week, and I expect you'll hear it again during this trial. This idea of accomplice liability, the idea that the people can get around the complete lack of knowledge or intent by President Trump. And look, the reality is President Trump is not on the hook. He's not criminally responsible for something that Mr. Cohen may have done years after the fact. The evidence will prove otherwise. You also heard a lot of communication about the 2016 election. The people just told you that the reason why these invoices were recorded the way they were recorded way after the election, President Trump was already in office, was to cover up for Mr. Cohen, suggesting Mr. Cohen was somehow trying to influence is the word they used, the 2016 election. I have a spoiler alert. There's nothing wrong with trying to influence an election. It's called democracy. They put something sinister on this idea. If it was a crime, you'll learn it's not. Michael Cohen paying Stormy Daniels or Stephanie Clifford $130,000 in exchange for her not publicly spreading false claims about President Trump is not illegal. I'm going to say that again. Entering into a non-disclosure agreement, objection, sustained. Entering into a non-disclosure agreement is perfectly legal. Objection, overruled. You will learn that these companies do that all the time with the same regularity. Executives, people who are wealthy, people who are famous, enter into non-disclosure agreements regularly, and there's nothing illegal about it. I expect that you'll learn that when Ms. Daniels threatened to go public with her false claim of this encounter with President Trump back in 2008, that it was, as the people just said, very close to the election, and it was almost an attempt by Ms. Clifford, Ms. Daniels, to extort President Trump. Objection, sustained. It was sinister, and it was an attempt to try to embarrass President Trump, to embarrass his family. Because as the people alluded to at the time, there were all kinds of salacious allegations going around about President Trump, and it was damaging to him and damaging to his family. And you heard and you will hear during the trial that President Trump fought back like he always does and like he's entitled to protect his family, his reputation, and his brand. And that is not a crime. You heard the people talk about this term, hush money payments, and I expect you'll hear that term used during the trial. Again, entering into an agreement with another individual, you'll hear this agreement was negotiated by lawyers. Objection. Please approach. Whereupon the following proceedings were held at the sidebar. Tell me what the objection is, Your Honor, specifically excluding presence of counsel defense. Sorry, Your Honor. There will be testimony from Mr. Cohen that he was a lawyer and that there will be testimony he was working with Mr. Davidson, also a lawyer. I'll direct you to stay away from it. Yes. So it was true in their opening that people talked about how Mr. Pecker's going to talk about his communications with the general counsel as well, which is also the same issue. Mr. Pecker is not on trial here. I understand. Whereupon the following proceedings were held in open court. The objection is sustained. All right, hold on, everybody. I've got to check. Oh my gosh. Hold on. I've got to check one more battery. Just a minute. We can't stay hanging here. I'm gonna find out what happens with the objections. Just a second. Let me plug this in. Oh, come on, little battery pack. Oh my goodness. All right, here we go. One more battery pack. Let's see. There we go. Yeah, I've not seen the puzzle piece come through. I've got to definitely have an eye on it. I've just not seen it come through yet. We'll have to, I find it very odd. It could be any time now. All right, here we go. Back into it. Let's see what happens. All right, so where were we? Okay, we had a lot of questions about these objections, so we're getting it clarified here. All right, there we go. Is it looking okay, everybody? Again, I've got my battery plugged in. The objection is sustained. The last comment is stricken. There's nothing illegal. Sorry, hold on, everybody. Let me just make sure I'm in the right order. There's nothing illegal about entering into a non-disclosure agreement, period. Now, the people talked about Michael Cohen, and there are going to be a lot of witnesses in addition to Mr. Cohen. You're going to hear myself, the other folks that work with Mr. Trump, cross-examine as the judge talked about these witnesses. Some will cross-examine a lot, some very little, if at all. But one witness you'll hear a lot about is Michael Cohen. Mr. Cohen served as President Trump's attorney for many years. Long before President Trump became president, he served as his personal attorney, working at Trump Tower, being paid by the Trump companies. And then, as I mentioned, in 2017, he served as his personal attorney to President Trump in 2017. After President Trump took office, you'll learn that shortly after the election in 2016, Michael Cohen wanted a job in the administration. He didn't get one. You'll hear that he was loyal. He was very loyal to President Trump and the companies for years. He defended President Trump on television, in printed media, publicly, privately. But unbeknownst to President Trump, in all the years that Mr. Cohen worked for him, Mr. Cohen was also a criminal. Apart from his work for President Trump and the Trump companies, he cheated on his taxes. He lied to banks. He lied about side businesses he had with taxi medallions, among other things. And as the people alluded to, in 2018, he got caught. Now, shortly after getting caught in 2018, you will learn that he made a decision. The decision that was made was to blame President Trump for virtually all of his problems. And he had eventually been disbarred as an attorney. He was a convicted felon, and he also is a convicted perjurer. He is an admitted liar. For many, many years, going back before President Trump became president, even before Michael Cohen started working for the Trump Organization, you'll learn that Michael Cohen was obsessed with President Trump. He is obsessed with President Trump even to this day. Today, Michael Cohen has podcasts, 2 of them. He goes on TV, X, TikTok, other social media platforms, and he rants and he raves about President Trump. He criticizes President Trump. He's talked extensively about his desire to see President Trump go to prison. He has talked extensively about his desire to see President Trump's family go to prison. He has talked extensively about President Trump getting convicted in this case. As a matter of fact, you will learn that the last night, 12 hours ago, Mr. Cohen on a public forum said he had a mental excitement about this trial and his testimony. He called President Trump just last night a despicable human being, among other things. And he said that he wanted to see President Trump in an orange jumpsuit. That was last night. But he says similar things multiple times a week during the entire pendency of this case, and even before this case was brought. You'll learn that Mr. Cohen has misrepresented key conversations where the only witness who was present for the conversation was Mr. Cohen, allegedly President Trump, and allegedly President Trump. He has a goal and obsession with getting Trump, and you're going to hear that. I submit to you that he cannot be trusted. Separately from his obsession with President Trump and his obsession to get President Trump on multiple occasions, Mr. Cohen has testified under oath and lied. Objection. Sustained. He has walked into the courtroom very near here, raised his right hand and swore to tell the truth, and now he will tell you, I expect that he was lying. Objection. Sustained. Please approach. Whereupon the following proceedings were held at the sidebar. There is no showing that Mr. Cohen testified falsely in any of the proceedings that Mr. Blanche is referring to. What I just said is what he testified, that he testified falsely. He will testify that when he pled guilty in front of Judge Pauley, he lied. That's not what I said. That's what he said. He did say that. That's not what is standing. I don't know what you're testifying about from the podium. We'll hear it from the witness stand. They can't use it against me. They can use it against me. That's in dispute. I read it's in dispute. It's in dispute. You're not going into that. Just to confirm, it's disputed both in the Pauley trial and in federal court in front of Judge Furman. It's his words. He said the question was asked, were you telling the truth when you testified before Judge Pauley? He said no. They said, were you lying under oath? And he said yes. He said he lied across the street. It is across the street. That's not what Mr. Blanche said. He said he lied across the street. Second, if you put the entire testimony in context and full, relax. Let him speak. I need to hear what he's saying. Both in his further testimony in that proceeding and in written submissions at his federal proceeding, he clarified and explained his testimony and said he was not lying when he pled guilty. Said he was prosecuted, believed he was prosecuted unfairly. This is an opening statement. It's not an argument. If you have this at the end of the trial, you can argue it at summations. I don't want to hear it now. Can't Mr. Blanche say, I expect the evidence to say? We heard from the prosecutor. We expect the evidence to say. We don't expect him to say. It's argument. You can bring it up in summation, whereupon the following proceedings were held in open court. The objection is sustained. You will learn, ladies and gentlemen, that Michael Cohen has pled guilty to lying under oath. That means, to be clear, that just like I expect witnesses will come in here and raise their right hand and swear to tell the truth, and then testify, that means that Mr. Cohen did that, raised his right hand, swore to tell the truth, and then lied, and admitted, pled guilty to lying under oath. So you have two meaningful, significant issues with Mr. Cohen: his obsession with President Trump and his desire to see President Trump go to jail in this case. His entire financial livelihood with podcasts. He's written several books. He's frequently on the media. His entire financial livelihood depends on President Trump's distraction. And second, the admitted fact that he's lied under oath. I submit to you, and I will talk to you again, as Judge Mershon has said at the end of this case, that given this, you cannot make a serious decision about President Trump relying on the words of Michael Cohen. There will be other witnesses. I expect Miss Clifford Stormy Daniels will testify. She is similarly extremely biased against President Trump. You will hear that he met her several years ago in 2006. I may have said 2008 earlier. In 2006, some 18 years ago. Then at the time, as some of you may remember, President Trump was running a very popular TV show called The Apprentice, which was always looking for new opportunities, and had a series of communications with Miss Daniels, but ultimately it did not work out. Since then, Miss Clifford has made a living off of those communications, even though she publicly denied any improper relationship in writing. You will hear that in the weeks and months leading up to the 2016 election, she saw her chance to make a lot of money, $130,000, and it worked. She got an NDA. Michael Cohen paid her that money. He did that in exchange for her silence, which of course didn't work. And since this story came out in 2018, became public, she's made hundreds of thousands of dollars because of it. She also wrote a book. She was paid for a documentary. And you'll also learn that courts have sided with President Trump in legal disputes between Miss Daniels and President Trump, and that she owes him somewhere around $600,000 as a result of those cases. But I'm going to say something else about her testimony, and this is important. It doesn't matter. What I mean by that is, I expect you will learn that Miss Daniels doesn't have any idea. She doesn't know anything about the charged 34 counts in this case. She has no idea what Michael Cohen wrote on the invoice. She has no idea how it was booked at Trump Tower. And she has no idea about the checks that were also charged in this indictment. So her testimony, while salacious, does not matter. That's not very nice. Now, I want to talk to you for just a few minutes about what the people spent a long time talking about, which is this catch and kill scheme between Mr. Pecker at AMI and President Trump and Michael Cohen as part of as the part of his lawyer. The people use the word conspiracy. You will hear and see that there are 34 counts in this indictment. Conspiracy is not one of them. My goodness. President Trump is not charged with any conspiracy. That's a word the people have chosen to use. The reality is there's nothing illegal about the scheme. There's nothing illegal about what you will hear happened among AMI and the National Enquirer and Mr. Pecker and President Trump. It happens, I expect you will hear shortly. This sort of thing happens regularly, that newspapers make decisions about what to publish, when to publish, and how to publish. It happens with politicians, with wealthy people, and with famous people. It's not a scheme unless a scheme means something that doesn't matter. That's not illegal. That's not against the law. As part of this, the people talked about a catch and kill idea. Catch and kill, that you purchase the rights to a story. But I encourage you to listen over the next couple of days. Well, listen to the whole trial, but certainly over the next couple of days, when you will hear Mr. Pecker testify about this supposed catch and kill. Listen to what he says about his motivation to sell magazines. Not surprising, and whether it was really a catch and kill or whether what the people just told you lines up with what the witness is going to say about that on the stand. So I'm going to sit down. Before I do, I'm going to say the same thing that the people said to you. Please listen to the evidence. Listen to the testimony. Listen to the testimony of Michael Cohen. Listen to the communications that folks had in the meetings that the people had in 2015, 2016, 2017, years and years ago. And think about whether it rings true that what they're saying is accurate and lines up with the other evidence that you hear. Listen to the folks that still work at Trump Tower. Some of them about what they did. They got those various documents that make up the 34 counts. Listen about whether that has anything to do with President Trump or anything to do with AMI or a catch and kill scheme or the 2016 election. If you do that, I submit you will reach the conclusion that it does not. And listen, use your common sense. We're New Yorkers. That's why we're here. And listen, use your common sense. We're New Yorkers. That's why we're here. You told all of us, you told the court, you told me that you would put aside whatever ideas you had on President Trump from the past 8 years. The fact that he was president, the fact that he was running again for an election this November, and we trust you to do that. We do. We trust you. You're going to decide this case based upon the evidence that you hear in this courtroom and nothing else. And if you do that, there will be a very swift, not guilty verdict. Thank you. Thank you, Mr. Blanche. Counsel, please approach. Whereupon the following proceedings were held at sidebar. I know you want to take a short break. You can do that, but I need to have the jurors out of here by 12:30. Well, what time is it? 10 to 12. So at this point, everyone, I will go ahead and break. So they did go ahead and dismiss. At this point, they had a break, and then they did come back, and we had Mr. Pecker come in and testify as our first defendant. He really only testified for about 15 to 30 minutes. And it was just kind of introductory foundation testimony, but they did dismiss for the day. So there you have it, everybody. Those are the opening statements. What are our thoughts? What are our thoughts? How are we feeling? How are we feeling about that? I'm trying to get both attorneys here in the picture. The moving face. You know, it's funny. I turned off all filters, but, it does add to it, I think. Oh, my gosh. Thank you. Oh, you're welcome. You're welcome. Need cookies and milk. I know. I need it, too. So, but, as we had spoken, what was really important to me, everyone, was trying to check out what had happened during those objections. So you can see, we had some sustained, we had some overruled, but either way, we just kind of kept on going. And that was the feeling that I had, but until I was able to read it out of the transcript, I just wasn't sure at this point. I think there's an automatic face recognition. Yeah, that's so weird because I turned everything off because I wanted to make sure that the sketches were true to their original form. So I apologize for that, everyone, but maybe that's fun. Thank you. Oh, yeah, the open statement slayer. Oh, my gosh, that's so funny. How does that judge keep a straight face? I don't know, but at one point, If you have a judge who's saying to counsel, like, relax, relax, you all need to relax, that's not a good sign. That's not a good sign. That's a sign that counsel's getting a little bit, getting a little excited. They need to calm down. Yes. So I thought, well, I was, I went through his opening, and I have to say I wasn't particularly impressed, but openings are tough. Although if you compare the two openings, everybody, if you compare the state's opening, he was like, bringing the thunder. He was bringing all the thunder. Meanwhile, this guy was like, it sounded like he was just flying by the seat of his pants. Like, did you have an outline, sir? Like, did you make an outline for your opening statement? Because I have questions. I have questions about that. The state's weak. Well, perhaps his attorneys are going to, well, perhaps everybody. It'll be interesting to see what happens. So, today, just as a quick summary of what happened today, everyone, we did have testimony all day long of Mr. Pecker. The day actually started with our contempt questions, right? Because the state had brought up questions and said we've got 10 different pieces here that we think have had violations of the gag order. So what happened was there was some tense moments between Judge Mershon and defense counsel, because Judge Mershon was saying, where's your information? What do you have to back up what you're saying? And he didn't have anything. And Judge Mershon had some questions about his credibility. And so it was pretty intense. They had a pretty intense exchange here. Judge Mershon said he would take everything under advisement and issue an order later, because I believe he wanted to move on and go forward with the witness testimony today. But he was not impressed here, and that's something when we have a criminal contempt situation. Now, again, I do not practice in New York, but criminal contempt situation, we have a court order, and there is a question about whether or not it's been violated, and the judge is the one that'll make that determination in a contempt situation. So if you are not able to get the judge to follow you, you're gonna have some trouble with that. You're gonna have some trouble for sure. Yes, I mean, and that can be a really big problem. You just have to keep in mind, we have a burden of proof that we have to meet in every situation. And even in contempt, we have a burden of proof that must be met. And the judge ultimately will make that decision. So it just sounded like he was not very impressed, not particularly impressed here by defense counsel this morning. So, and it seems like he's willing to go both sides, kind of, kick at both sides. So I'm not finding that he's particularly, leaning one way or the other. But having attorneys on the jury will be positive or negative. That's a great question. So rumor has it that we have, again, I won't confirm or deny too much information about our jury, but there has been discussion here that we've got two of our jurors who are attorneys. And, a lot of times, and people ask that a lot, and this is just to give you a visual, we've got our 12 jurors and then our 6 alternates. And many times you don't really, a lot of again, it depends on what you're going for, but we struggle to have attorneys on our juries because we don't want someone to lead the jury or dominate the jury. We want every single juror to feel like they're all on the equal playing field, they're all listening and deliberating, and everyone is starting at the same place. But when you have attorneys on the jury, then the assumption is, well, they've kind of already got this inside view of how the law works. And so that they can kind of pull this leadership role, or sometimes be asked questions that, shouldn't necessarily be asked because of deliberations. During deliberations, you have certain rules. And if you've got attorneys in there, they may be asked those questions. But on the flip side, because they're attorneys, they know they can't answer those questions. So they know that they're not supposed to interject anything into deliberations that's not allowed, that they haven't seen during the trial or during the jury instructions. So hopefully they'll just stand up and say, I do patent law. I don't know anything about this. But, on the other hand, I'm not really sure. if you think about any of the professions too, doctors make bad patients, and they say too, attorneys make bad jurors. But I know we have a judge in my jurisdiction who has gotten pulled for jury duty twice and has actually been chosen. And, he's like, dude, I had to serve in a jury trial, and he's a judge. So it just really depends. Can you be fair and impartial? If you can, and we really feel like you can walk that middle road, then, you can get picked. But I don't think that this case is too complicated where it's going to really need attorneys to walk people through it, which is on the one hand. But so I would say I'm not overly worried about it because of the nature of the case, and also because of how the system works in this particular jurisdiction. So I think it's interesting. I'm wondering, I'll be very interested to hear what they have to say after the trial. I think they will have a really interesting perspective of it. I think all of the jurors will, but in particular, the attorneys will, coming from being able to say, wow, this is really interesting. A lot of attorneys want to serve on juries, but, I've been called for jury service multiple times, and I just can't stop the sass. I get in the box and they're asking me questions, and I'm just like, sassy time. And they're like, nobody, you don't want sass in the box, everybody. So you don't get picked. And so I was eliminated, because of that. And I think one time I was also a law student, and the judge was like, I don't want to give you any breaks, but it was right during finals and those kinds of things. So he let me go. But you really want you want plain vanilla, middle of the road, just, walking down the garden path, just regular people. That's what we're looking for our jury here. Our regular people are the ones that we're really looking for. So sometimes people say if they're a teacher or a journalist, I'll never get picked. But you never know. It depends on the trial. It depends on the facts. It depends on, how you're presenting yourself that day. And if you're just having a day where you're like, whatever, maybe that's the day you'll get chosen. So they don't seem to pick teachers. Well, I think it depends too on, it depends on how you're scheduled too. I think it'd be difficult for teachers to get pulled. I will have to say I have someone in my world whose history teacher was just pulled and will be in trial for the next 2 weeks. So it does happen. It does happen. What if you're different though? Different is okay. Different is okay as long as it's not harmful different. We want all kinds of different ideas. And when I'm saying plain vanilla, I'm talking about ideologies. I'm not talking about, appearance or personalities. I'm talking about, can your ideology, can you be perfectly neutral? Can you sit in with your own beliefs and your own way of thinking of things, put that to the side, just look at what's in front of you and make your decision. So that's what I mean by plain vanilla. Someone who's able to put aside their own thoughts and biases and just look at what we're presenting to them. What do they pay jurors? Oh, it's like, oh my gosh, I think 15 in my jurisdiction, it's like $15 a day, I think. I think they got a raise. It used to be $12. I think it's 15. I got called 3 times. They didn't need me. Oh, I know. University admin. I often get picked. Yes, of course. I can see that. But yeah, we really are looking for someone who can look at the facts in our case and tell us and give us our verdict. You may think like, oh, we want to definitely pick the people that are for our side, but that's really not the mindset when we go in. We want, it's a process of elimination, so we're eliminating those that we know will be against us, and then whomever is left is what the jury is. So rather than going in and saying, I must have this person on the jury, we flip it around. Our thought process is this person cannot be on this jury, and we use our strikes strategically in order to make sure to remove those that we think would be the most harmful. Oh, yes. Oh, VC, it's tough. It's tough. It's such a hassle, and it's so stressful when you have to check and see oh my gosh, is my trial going? Is it not going? And most of our cases settle. Everybody, the civil cases as well as criminal, but particularly in criminal cases, they will plead out. But for those times that they do go forward, like we have to have our fact finders. Like our system wouldn't work without it. 3 times in 1 year. Oh my gosh. Oh my goodness. Now, the other thing too is if you're pulled for a grand jury, that process is different than if you're pulled for a regular trial jury. So usually you'll get pulled in for a longer period of time. So you serve like 3 months as opposed to just a few weeks, but you come in for a day and you hear like multiple cases all in a row rather than a full trial. So you can get multiple jury verdicts done in a short period of time, but then they're also called in multiple times. So the verdict or the grand jury process is a little bit different. It's a little bit different. Never been called. Oh, interesting. Canceled each time. Yeah, small town. Well, in most cases, don't go. I mean, that's the reality of it. We do everything we possibly can to settle our cases out, to plead our cases out. But sometimes you just get to a point where you can't. And with Mr. Trump, again, it's never ceases to amaze me that we have no plea deals here. We have no negotiations here. We're just going to trial for everything. All of his civil cases are going to trial. All of his criminal cases are going to trial. That's what makes this so incredibly unusual, because at this point, people would be pleading out. Like if he took this and just sat down and pled this out to a lesser included offense and maybe just 5 misdemeanors instead of 32 or 34 felonies, they could have worked that out. Yeah, he would have had a misdemeanor, but they could have taken jail off the table and he could have pled out to that. He'd still have a record. So, the state would still have the accountability, but then Mr. Trump will be moving on with his life. But instead, he's fighting 34 felonies. So, and he's got that right to do that, but that's very unusual. Red flag occupation that would cause you to dismiss a prospective juror. So I don't think there's a red flag occupation. I would say that there's definitely a red flag type. For me, for going in, I don't, the type that really is a big red flag is if they argue with me. When I'm just asking questions and I'm shooting different questions and we're working through voir dire process and I'll say something like, do any of you know anybody that's a police officer? And someone will say yes. And I'll say, oh, okay, well, who is it? And, are you close to them? Are you related to them? And then instead of giving me straight answers, they're just like, I bet you want to know who I know that's a police officer, blah, blah, blah. And I'm like, well, I do. That's why I asked the question. And they keep going down this kind of, road of like, wouldn't you like to guess if it was a cop or if it was, a deputy? Wouldn't you like to know? Like, yes, I would. I'm asking the question. Like it wastes my time. And so for me, that's frustrating because I feel like they're not going to be able to follow the rules. They're not going to be able to follow the jury instructions, and it's going to be a fight. So, it's one thing if people want to be sarcastic and kind of, lighten the mood a little, that's fantastic. But when they're really, really fighting with me, that's very frustrating. And I don't want to have to fight for like who, I don't want to fight and say, if someone comes at me from the perspective of like, just because you're a lawyer, you think you're smarter than me. That's another big red flag, because when you're in front of a jury, it's like your intelligence, who cares? Like, I'm there to win a case. I'm not there to, figure out what your life choices were. And if they come at me like, well, just because I didn't go to law school doesn't mean I'm not smart. I'm like, well, obviously not. You're here. You're the most important person to me right now. That's really important. So that would kind of be another big red flag is like, dude, we all pick just different careers. If you are, a plumber, like seriously, that would be, who cares? That's a fantastic life choice right now. Who cares what your job is? But for me, I'm just doing my job right now. So let's move on. So that's definitely something that's been frustrating over the years. Has been like, hold on, calm down. Calm down. I'm just here to do my job. there have been many times when I have walked into situations and, again, if it's been known, like, oh, well, she's an attorney, and I'm just like, I'm not here to hurt you. I'm not here to hurt anybody. Oh, you're welcome, of course, of course. But sometimes that feeling definitely gets there. I remember I walked into a meeting with a few people just to have it. We were just having to sit and talk. It wasn't any big deal. And this insurance agent guy was like, "Oh my gosh, you're an attorney. I can't speak to you anymore." I'm like, "Wow, dude, calm down." I'm like, "I'm just here as a friend." I'm not trying to hurt anybody. But that can sometimes happen. But I wouldn't say there's any one career that I would rule out. Truly. I don't think that, it really isn't about the career, it's about the person. But that's also my personal view on voir dire, and that's my perspective on picking a jury. And all attorneys are different. Some attorneys feel like, if you come into the courtroom and you're reading a book and you are not engaged with anybody else and you're not talking to anybody else, you're perfect and they want you no matter what. Or if you're real chatty with somebody else, or someone who brings knitting or something to keep their hands busy, that could be a symbol that, of how their mind works, that they have a very logical mind. So there's like a whole school of thought on how to do an analysis on people by just looking at them sitting in the room before they even come to the box. So it's very interesting. It's very interesting. Do you miss practicing in the courtroom? I do. I miss it. I miss it a lot. I do. I miss it, but I also am happy to be here. I'm so thankful. I'm so thankful to be here chatting with all of you, but I do miss it. But time moves on. You can't do it for everybody. You can't do it forever. Can't do it forever. We're so thankful. Yes. Oh, I'm grateful too. I'm very thankful. It's always so fun to come in and chat with everyone here, to have a chance to hang out and explain how things work, because it's really, this can be really overwhelming, very, very overwhelming if you haven't been doing it. So I'm happy to come in and try to help. So yeah, and not everybody is going to be a trial lawyer, and you don't need to be. You don't need to be. Most of our cases, we're going to settle our cases, our civil cases, we're going to settle those. You don't need to be. Not everybody needs to be. And so, a lot of people go into law school and they're like, oh, I'm going to be a trial lawyer. And then, they go out and they do it for a year and they're like, this is the worst thing ever. I'm never doing this again. So it just depends. And for me, I was always, for me, the whole world just disappears when I would walk in a courtroom and I just had my task in front of me. And that kind of very narrow focus for me was just, the best thing ever. Always enjoyed. It was tough. It was hard times sometimes too. And of course, when you lose your cases, it's difficult, but when you go in and the whole world just fades away and you're just focusing on trying to get the right thing, trying to do the right thing and help people. And, that's what everybody wants to do. So why the judge sustained that immediately overruled? No, it looks like we don't have an answer to that. And, as I was going through the transcript, it doesn't seem clear. It seems like he wanted to get enough information from the defense counsel to be able to figure out where he was going, but then he also needed to rein the defense counsel back in. So it didn't seem like there was a lot. I was asked, yeah, there's always that question. Is anyone in your family part of, oh, thank you, Kristen. Oh, you're so sweet. Yes, there's always that question. We just got to make sure, and because if you have someone in your family that's in the field, that could, have your views go one way or another. For judge to place a gag order on witness, it's possible, Frank. Absolutely. It's definitely possible. Criminal, no, general, I focus on civil rights. Yes. Oh, thank you, Sarah. That's hard work. That is hard work. Fighting the good fight out there. Yikes. Yeah, that's hard work. It's not everybody, and not everybody needs to be. Not everybody even needs to be an attorney. I would say our entire field is built on our paralegals and our law clerks and our support staff, whatever you call them in the firms that people are working in. whatever, our administrative assistant, our help. I always feel like it's much like the military. Like you see the ones that are out like in the fields, in the trenches, and you're like, yay. But, behind them is like 85% is the administrative staff that's taking to get them there. And that is so true in the legal field. Our staff are people that support us. They make it so that it's possible. Our paralegals are amazing people, and so you certainly don't need to have a law degree to make a huge difference. About today, when the defense had an objection, why was the jury taken out? So sometimes when an objection happens, the judge can call them up to the bench. But if things are kind of getting real like testy, which it seems like is happening sometimes between these attorneys, if things are going to get a little bit heated, then the judge may ask the jury to leave just to kind of make sure that they don't get any negative connotations from it. So that's not particularly unusual. If the judge thinks it's going to take a little time to really work out what the objection is, and he's going to need a few extra minutes and things are going to get real heated, that's pretty much protocol. Yeah. My brother, yeah. I mean, state trooper, yeah, the top of the top. But I mean, that's not necessarily a boost against you if you have someone in your world that's law enforcement. But it's a combination. You get like a certain number of ticks, and then it's like, well, that one's not going to work. So paralegals are amazing. Oh my gosh, absolutely. Paralegals and legal assistants, and I mean, they are helping us in our insanity. Do I still practice? Not right now. I'm on a bit of a sabbatical right now. So, but I did and did love my time practicing. So, really, Superior Court Reporter. Oh my gosh! Oh, our court reporters. Wow. I mean, that's like the true heroes. Our court reporters for sure, everybody. Well, I'm checking the clock, everyone, and I'm going almost into 2.5 hours. So, oh my gosh, did I watch Better Call Saul? Oh, I should. I've heard it's really good. Paralegal for a long time. Yes, thank you. I'm glad. Oh my gosh, everybody. Oh, look at all those likes. Thank you so much, everybody. I will go ahead and sign off for now. Now, I am planning to be back tomorrow, 7 o'clock Central, to go through the testimony of Mr. Pecker. Now, it's going to be what we would say in the business. I'm going to put this in as a soft confirmation because we'll have to see exactly what tomorrow brings. But I'll give you a soft one, and I'll make a post to firm it up. That's what we would say in the business. I'll give you a soft yes, but I'll firm it up tomorrow just to let you know. I'm hoping to be able to come back again tomorrow at 7. Yes, but that should be really interesting. And I'll probably cut some different pieces so that we don't have the entire testimony because it can get pretty tedious. But I think there were some definitely interesting pieces out that we could talk about. So we'll hopefully be back on again. Yes, I'll need to rest my voice, but I'll be back on again tomorrow. Thank you all for coming and hanging out with me as always. So much fun. Oh, thanks, Embers. Thank you for all of the support, everybody. I appreciate it. It was so fun reading through the arguments. I was so glad I was able to do that. So, yes, my most likes ever. Oh my gosh, everybody, 450,000. Wow. Stick puppets. Yes, I need to do that. Oh my gosh, that would be funny. All right, have a great night, everyone. I will say goodbye for now, and we'll see you again tomorrow. Thank you all for the support, and moderators, thank you so much for everything that you do.